putting in place. There we go. Well, welcome everybody to Privacy Law Changes and What You Need to Know Now. Today's the 12th of February and this recording will be available for people in the future. Now the timing of this recording is really important because Australian privacy laws are going to change on the 12th of March. So we've got 1 month and it's the shortest month of the year before we need to be really organised in terms of what we're doing in business. Now we've got a couple of, I should introduce myself, sorry about that. For those of you who don't know me, my name is Jeanette Jifkins. I am a qualified lawyer. I have the right to practice in Queensland and Victoria and in the High Court of Australia. I've been in practice for around 15 years. Previously, or in my early career, I was in law firms and worked in different areas such as litigation and dispute resolution, and then moved into corporate advisory work. Then about halfway through my career I moved into in-house, which means I started working inside companies and advising the company about what legal issues it faces instead of dealing with a bunch of clients in a law firm. And then about 4 years ago I got involved with Andrew and Daryl Grant with Our Internet Secrets and found them to be fantastic mentors. They encouraged me to go into looking at the legal issues of doing business online and helping people, particularly in that area. So that's a little background of where I come from, and this is the first webinar that I've done by myself. I've been interviewed on plenty of webinars, but this is the first one I've hosted myself. So thank you to Mark Robinson for helping with the setup of the webinar. Alrighty. Privacy. Now there's the fine print you need to know as part of this webinar. This webinar is being recorded. There will be questions at the end. You are consenting to being recorded if you participate in questions, and unfortunately I can't do anything about that because of the way this is set up. I'm not going to edit the webinar afterwards and take out people's voices. So if you participate and speak on the webinar, it will form part of the recording, and that's not revocable. You don't get paid for participating in the webinar. It's a free participation. The recording will be publicly available, and copyright in the recording belongs to Law4 websites. So there's your fine print. Now, getting into the meat of privacy. Is your business affected? If you're a private entity, so you're a company, a trust, a sole trader, any of those sorts of things, a partnership, as a small business, now a small business is $3 million turnover per annum or less, now you're covered. Previously, small businesses were exempt from privacy law obligations, but come 12th of March, that will all change. Government and semi-government entities have all been covered since 1988 when the Privacy Act was first introduced. It's expanding. So as I say, small business is affected. If you are a health service provider, you have been liable to protect private information consistently since the beginning of the Privacy Act. Well, not quite the beginning of the Privacy Act, but for a fairly long time. So if you've got any sort of health information, then yes, you should know about your privacy obligations. If you're in the business of collecting personal information, and I actually had a chat with somebody on the weekend who has the business of running a directory. So they go out there and they source information and they put it into a directory and they make it publicly available. That is actually covered by privacy law now. And credit reporting agencies and credit providers have always been covered by privacy law and had privacy obligations. For credit reporting agencies, the ability to report more information and to record more information is what will happen with the change in the Privacy Act come 12th of March. So getting down to brass tacks, what is personal information? Personal information, for one, it's information. It can be opinion, and it doesn't have to be true. It just has to be recorded in some form that can be distributed or accessed. It needs to be about an individual as opposed to a business. Now, the person I was talking to you about before, who has a directory, her directory is aimed at businesses, but some individuals are named in the course of that directory because they may be sole traders. Because an individual can be identified through that information, then it is covered. So yes, it's about an individual as opposed to a company, and the identity has to be what personal information does is it makes a person's identity apparent from that information or reasonably ascertained from that information. So if you can see a couple of pieces of information and together they help you identify an individual, then that is still personal information. Okay. Now, there are different ways to collect, use and hold personal information, and these are technical terms in the legislation. So they're not exactly what you might think they are. Now, holding information can just be inadvertently collecting it. So I don't know about you, but I have a huge inbox. And anybody who is storing emails that come in, and they might answer them and then the responses sit there. Sorry, I just had a question. What do you mean by covered? And what I do mean by covered is that it does come within the scope of legislation and you are bound by the legislation and may face penalties if you don't comply. So your business, as a small business, if you are collecting personal information, you now have obligations under the Privacy Act. And collecting personal information can be as simple, or holding personal information can be as simple as an increasingly sized inbox. So when you get an email, if you don't have any process for dealing with that, you're holding personal information. Ordinary mail, stuff that you might file in a filing cabinet, if it's got personal information on it, which can be as simple as a name and an email address, or a name and a phone number, name and address, any of those sorts of things, that's personal information. You can also access it from other sources. So I have worked with a business where we had to put a statement on a directory that that business published of its members. Now, it published that directory for the purpose of people being able to source services from those members. The trouble was promoters were coming in and saying, hey, this is this is exactly my target group. I want to market stuff to this group. And they would scrape the email addresses off that website and then go and promote information to those people. The people who were on the list, for the purpose of providing services, got pretty upset when they kept getting all this marketing information. So to get around that, we had to put a statement on the website to say this information is for this purpose only and is not for marketing, and the people who've put their names on this list do not consent to receive commercial information. So that's how we got around that. Now that's actually a spam issue as opposed to a privacy issue, but you can see how they're all interrelated. Generally available publications is a way of collecting information and making it available. So you might, for example, there's a hole-in-one publication. So everybody in Australia who gets a hole-in-one on a golf course, that gets recorded. When it's recorded by the club can now send it to a publisher, and the publisher will put it in a book, and then everybody whose name is in the book can say, hey, look, I can prove that I got a hole-in-one because my club's endorsed the fact that I did it and I'm now published in this book. That is a generally available publication. It doesn't have to be paid for. It can be free. And that's a way of collecting personal information and making it available. Now, using personal information, somebody's thrown me a question about clients. The information that you collect about clients is personal information. It is covered by the Privacy Act. And this is why I'm saying as a small business you now have concerns, because every client file that you have that you didn't worry too much about before, you now need to think about how you're dealing with that information and how accessible it is to other people within your office and what you do with it. So I've got a quick poll for you, and I'm hoping this works. You should have up on your screen a quick poll, and if you want to tick one of those boxes and submit, then we'll see how many of you are aware as to whether or not you're collecting personal information. Okay, give it a minute or two. We've got, oh, this is fantastic. It tells you how many people have voted. 62%. 30 seconds. We'll give it 5 more seconds. Okay, that's 86% of the people attending voted, and every single one of you have said that you collect personal information. So I'm glad to see that this information is relevant to you. Alrighty, if you have sensitive information, you've got extra obligations and you have to be more careful around the way you keep it. Sensitive information, just so that you're aware or have a level of awareness around what it is. Health information, information collected for the purpose of immigration. It can be race, ethnicity, political opinion, trade union membership, sexual preferences, criminal records, all sorts of different things. That's sensitive information, and if you look into the anti-discrimination legislation, it's pretty much everything that's covered in anti-discrimination is considered sensitive information. But then on top of that, you've got the health and the immigration and things like that. Just be aware that if you're collecting any of that information, that you've got extra obligations. We won't go into detail into what that is because most people don't collect sensitive information. Okay, the Australian privacy principles. Now this is the big change. What's happened in the Privacy Act previously is you had information privacy principles and you had national privacy principles. And the national privacy principles applied to organisations and the information privacy principles applied to government and semi-government organisations. They were similar but they had differences. What they've done now is brought it all together and said, okay, the Australian privacy principles will replace both of those, and we will end up with one set of privacy principles that apply to everybody across the board. Those privacy principles, there's 13 of them, and I'll just go through the headings with you and give you a really quick snapshot of what that's about. The first thing is, and this is new, this wasn't in the previous version of the privacy principles, you've got to have open and transparent management of personal information. Now it was implied before, but now they've spelt it out and said you have, this is the key philosophy around what you're doing with personal information. So open and transparent management of personal information. This is why you have a privacy policy, because you tell people what you're doing with the information you collect from them. Sorry, I'm just going to take down the poll. Can you let me know if it's gone? And if it's not, then it's gone. Okay, fabulous. Alrighty. Back to Australian privacy principles. Now I'll just flick back to the other screen in case you missed that. The extra obligations, that was sensitive information. So if you want to have a, thank you everybody for letting me know it's gone. If you want to come back to the webinar later and run through the sensitive information, there's a list of them for you. Okay, Australian privacy principles. The second one is anonymity and pseudonymity. Now the whole purpose for this was to say that people should be able to access information without having to be identified. And this is going to be interesting with all those marketing websites that say you can't get this information until such time as you log in. And I don't know about you, but they really bug me. I hate searching and then finding a website that's supposed to provide me with the answer I want, and it wants me to log in before I can access it. You know, it might be just the price of something I want to buy, but I can't even see the price of something I want to buy unless I log in. Well, potentially that could become a breach of the privacy principles, because you're requiring people to identify themselves before they can get access. And the privacy principles say you've got to give people the opportunity to be anonymous unless it's essential to your service provision that they're not. Now, there are bodies out there. So, for example, I work with an accreditation body, and from time to time they accredit university courses, and from time to time they receive complaints from students. Now, there's nothing they can do with those complaints unless they know who the student is and where they've come from and what course they've done. Otherwise the information's meaningless, and they can't go back to the university and say, hey, there's an issue. So in that particular case, they don't have to provide anonymity. They can require a person to identify themselves. But if you're just giving information on the internet and it's otherwise freely available on other websites, then requiring somebody to give you their identity first is potentially a breach. Okay, collection of solicited personal information. Now, what this means is putting a name capture on your website. Now, there's the anonymity issue is only if you make people give you their name and email address. Collection of solicited personal information, generally if you've got a web form on your website that says, here, give me your name and email address, what you're doing is saying to people, you have a choice. You can do it, and as a bonus we'll give you a report. But the balance of your website they can access without having to give you their contact details. It's just a special thing. In order for you to deliver that particular report or book or whatever it is that you're giving to them, they need to give you your details so that you can actually send it to them individually. Now, you may be able to provide that free on your website, but the purpose of providing the report is to attract or identify people who are really interested in the products or services that you have to offer. So there's a leeway in collecting information that way, and it's mainly because people have a choice. Unsolicited personal information is where you might go and buy a list. And what I mean by this is, for example, if there's a big workshop or convention with lots of stands and people pay to get in, like the home and garden conventions and the boat show and all those sorts of things, what tends to happen is a list is created either of the attendees and or a list of the exhibitors. Those lists can be made available for purchase. And it doesn't mean you're necessarily told that they are, but I'm aware of a business that used to buy lists from bridal expos in order to market to all the people who attended bridal expos, because that person had a product that, you know, was very popular with newlyweds or for newlyweds as wedding gifts. If you're going to go and do that, that's unsolicited personal information, and you're going to have you've got to take extra care around using that information. Now, the advice I gave people on the weekend was, yes, you can send something to these people. Don't market to them. Send them an invitation to receive marketing from you. So you say, hey, this is who we are, this is what we do, we have a newsletter, you can subscribe this way. And if they choose not to, then you don't market to them again. So you can't buy a list and then add them straight in and then just start marketing to them without their permission. If it's unsolicited personal information, you have to get their permission first. Okay, next set of privacy principles. Notification of the collection of personal information. Now, this one I find particularly troubling because I seriously don't think it's workable from a practical perspective. Now, regardless of that, what it says in the legislation is that if you collect personal information, particularly if it's unsolicited, then as soon as possible after collecting that personal information, you're supposed to contact the person it relates to. Tell them you've got their information. Tell them why you've got their information. Tell them what you're going to do with it, and how it came into your possession. That you may choose to do that in some form of email in inviting them to be involved with you. I just think it's going to be onerous where, say, people throw a whole lot of business cards into a bowl at a function and then want to use that information to market to those people. Then potentially under this they have to explain all the purposes of how, why, and so on and so forth before they can use that information. Maybe it's fair, maybe it's not unreasonable. Your use and or disclosure of personal information has to be managed. So this is something as a small business we all need to be aware of. And I don't know about you, but I do have an inbox full of emails, and I have not previously gone through and categorized a lot of those emails to say, yes, I should delete this, I shouldn't retain this information, I should store this information in a particular place, all those sorts of things. Right now I'm not actually using it, I'm just holding that information. What I should be doing is making a decision as to whether or not I'm going to use that information, and if I'm not going to use it, I should be deleting it. The issue of disclosure is, what do you do with personal information? So if you're collecting it through your website and you're building a list of people, don't share the list unless you have permission from the list to share it. Now that doesn't mean you can't promote someone else through your list. So an associate of yours who has a complementary product may come to you and say, hey, look, you've got people who may be interested in what I do. How about we put something together and we market it? Now, a great example of that is the Harry Dent seminar series that's going on around the country at the moment. Harry Dent is an economist from the US, and he has connections in the seminar network in Australia. He's currently on an Australian-wide tour, and all and sundry are promoting him. Now, I'm on a number of different people's lists, and I think I received 4 different promotional emails for his presentations, because clearly he's got involved with a whole bunch of people. And they've not given him their list, but agreed to promote what he's doing to their list. All right, direct marketing. Now, you can build a list for the purpose of direct marketing. What the Australian privacy principles say now is, if you're going to do that, tell people. So your privacy policy should say, hey, if you give me your name and email address through the web form on the website, I'm going to add you to a newsletter list, or I'm going to send you to a marketing list, or I am actually going to market directly to you. Now, a lot of people understand that when they put their name and email in a web form. Just in case somebody doesn't, that's where you need to put it in your privacy policy. Cross-border disclosure of personal information is the new flavour of the month, and the reason this came about is because the big banks and telcos have outsourced a lot of their customer service overseas, and a lot of people have got upset because when they first started doing this, what was happening is all of these contact details and customer details were being outsourced overseas, and then the information was being on-sold to other entities overseas. And people were getting all sorts of calls and emails and letters and marketing from people they'd never heard of before, just because they happened to be, you know, a telco customer or something like that. So that's why it's become really important. It's because a whole lot of people were upset because their personal information went overseas without their knowledge, and then it was misused. So it's unlikely nowadays to be misused, but it's our obligation as an Australian business entity, if we're going to use overseas service providers, customer service, whatever we use them for, we are obligated to make sure they comply with our privacy obligations. We can't just throw up our hands and say, oh, well, they're overseas, it doesn't apply. We actually have to monitor what they do and control it. Now, I did say I would leave questions to the end, and I'm getting quite a few of them now, so I'm sorry. I do understand that they are relevant on the way through. I just can't do both things at once. So what I'll do is I'll come back to the questions for a second. I'll read out a couple of questions for you. Could a wholesale organisation request a login and approval before providing catalogue information, such as a fashion wholesaler? They do. To be honest, they do. That's part of the problem. And at the moment they can, but it'll be interesting to see over the next couple of months, as soon as these Privacy Act changes come in on the 12th of March, what the Privacy Commissioner does about it. Because they're supposed to make that information available to people who choose to remain anonymous, as opposed to requiring people to give information. So they can, what they should be doing in terms of requiring a login is actually making it a choice, particularly if that's the only stuff they're putting out there on the internet. What's the consequence of using email? This is another question. What is the consequence of using email information other than for the purpose they thought? For example, signing up for a free report and then being added to a general newsletter list. Well, in Australia, we're really lucky because our privacy law does say that even if you give your personal information to somebody for a specified purpose, so for the purpose of receiving a product, that company or that person can add you to a list and market to you if it would be reasonably expected by you. So if you go on to a website and you download a book, you give your personal details to download a book about property investment, then it would be reasonable that you receive some marketing around that complements property investment. Now that may be around finance, that may be around home decorating, that sort of thing. But you wouldn't expect to receive marketing for, say, a trading platform, a share trading platform, because it's not, yes, it's maybe investment, but it's a different category of investment to property investment. So you've got to be careful what you're marketing to your list and how it's complementary to what you do and what they signed up for in the first place. Another question, what if I sold my business as a total entity? Can I pass my list of subscribers or customers to the new owner? Yes, you can. If it's a business, your list is a business asset. And you can, but what you should be doing is letting your list know that the business has been sold and the new owner has taken it on. And you can make provision for this in your privacy policy. So you can say in your privacy policy that personal information will be transferred to the new owners if the business is ever sold. Simple as that. Okay, somebody's asked me, is Harry Dent doing anything wrong, or are the promoters of Harry Dent infringing new privacy laws? Well, the laws aren't in effect just yet. The people who have sent me his information, it's not unexpected. As far as I'm concerned, I'm not surprised that they sent me that information, because consistently they've done that over the last year or 2 years or however long I've been on their lists. So it's not something unexpected. It's not a big surprise to me, and I can, it doesn't bother me that that's come in on my email address. However, if, for example, I was in health and wellness and the health and wellness subscription service that I signed up for is all about motivational quotes, I get a daily motivational quote, and then all of a sudden they give me a promotion of Harry Dent, I might be put out. And that's where there's an issue, whether it's reasonably contemplated by your list that you would get this kind of information. How is it going to be policed? Somebody's just come up with that question. Well, this is another one of those government entities which works on the complaint system. So the more complaints they get, the more investigations they'll do. They have, from what I understand, and this is just gossip around the traps, but from what I understand, they already have a few business sectors targeted that they want to investigate as soon as these laws come into play, and sort of test how robust the laws are in terms of what the decision makers are going to say about it and how many fines they're going to be able to collect. So it's going to be interesting to watch what the Privacy Commissioner does over the next 6 to 12 months, but I would not be surprised if there is a few companies that collect some pretty hefty fines for the way they manage their personal information. Now, as a small business, what does this mean for you in terms of risk? Well, it means you probably have a low risk as long as you keep your customers happy. Now, I was talking to somebody recently and we discussed the fact that in any business, no client base is going to be 100% happy all of the time. You're going to have 1 to 3% of your client base unhappy for any particular reason. It may have nothing to do with you. You may just trigger what they're upset about today. You don't want your clients or customers or people on your list complaining to the authorities, because when you come to the attention of the authorities, they don't ever let you go. You become sort of part of their hit list. So they never hear about you before and all of a sudden they get one complaint, and if it's a really serious complaint then you're almost on a watch list. And I'm not involved in the inner workings of the Privacy Commissioner's office, but I have worked with Consumer Affairs before on behalf of clients, and seriously I've had clients that really struggle to do business after they've come to the attention of Consumer Affairs because they've ticked off 1 or 2 customers, and then Consumer Affairs come after them every 6 months or so to check that they're compliant with what they're doing. So in terms of it being policed, it may not be a big deal to start with. They may go to the bigger companies, but it could become a bigger deal down the track, and if any one of your customers complains about you, it's not a position you want to be in. Okay, I'm going to move on with the slides again and then we'll come back to some more questions in a minute. Now, the last of the privacy principles are the adoption, use or disclosure of government-related identifiers. Now, this has more to do with particularly health service providers. So with the new e-health system, if you're a health service provider, you may or may not have a permission to use, say, a Medicare identifier to identify your clients. If you're in a different industry, say your small business, whatever your small business is offering, if you asked people and said to them, hey, I want your tax file number, and then you identified all your clients by their tax file number, so in your lists and everything, so that their personal information wasn't the primary identifier, then you're in breach of the privacy principles, because there's a specific prohibition against using those sorts of government identifiers to identify your client base or relate to your client base. And that's part of the reason if you're employing people and you collect their tax file number, you do it on a form that needs to be kept securely, and you shouldn't make their information publicly available on any sort of payroll system for the rest of the business. Okay, the quality of personal information, what we're talking about there is whether you've got it right or not. Now, if you remember back in the beginning, personal information can include an opinion and it need not be true. So the quality of personal information is a little bit of a contradiction, but essentially what it's coming back to is making sure if you retain personal information for a specific purpose, and particularly if you're going to make it available in a public publication, so a directory, that you keep it as current as possible. And people if you have a look at 12 and 13, which is access to personal information and correction of personal information, your clients, customers, whoever it is on your list, have the right to come to you and say, hey, that's wrong, or what information do you have about me, and can you tell me what it is so that I can correct it? Okay, I've just had a flag. Somebody said they've lost audio. Can anybody just send me a message and let me know if they're having troubles with audio as well? Audio good. Okay. Alrighty. So most people can hear me. So if you're having trouble with audio, it might be your end. Okay, great. All right, moving on. Access and correction of information is about allowing people to come to you and say, hey, what have you got? Let me know what it is, and I will tell you whether or not it's right. Now, if somebody wants to correct their personal information, particularly if there's opinion in there, they can give you the information, but it does not mean that you have to replace what you've got with what they give you. So if what they give you is contradictory to what you say it should be, and this came about mainly with medical information, particularly where doctors were putting opinions and comments about their clients into medical files, and then clients were accessing those files and saying, hey, I'm really not happy about this. So if a doctor's written in a medical file, this client's a hypochondriac, blah, 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 the client comes back and says, what personal information have you got about me? Show me that. Hey, I'm not a hypochondriac. I expect you to delete that. Then the doctor actually has the right to say, well, I disagree with you. I will record what you're telling me and I will put it with the personal information I've got, but I'm not going to change what I've got. So that's the ability that you have in terms of maintaining personal information. Now the last one is, or I've skipped over it, but coming back to number 11, the security of personal information. What that is you actually need to understand the security around your systems. So we were talking about inboxes before. If you've got a full inbox, does your computer have some sort of password access or finger scan access or something so that everybody in the household can't just get in there and read through it? So that's really coming back to basics of the security around personal information. It's making sure that it's not readily available to anyone but you unless they're an authorized person in your business. So it doesn't mean that you have to restrict the flow of information within a business. It just means you need to be really aware of how it happens and who has responsibilities around it. Okay, basic compliance. Just to get yourself over the line and make sure that you've got basic compliance, you can at least respond and say, yes, I understand I have obligations and this is what I've done which I feel is reasonably practical in my circumstances. Have a privacy policy. Now, I asked a room full of people on the weekend how many of them had read their privacy policy, and it was about 5%. So if you've got a privacy policy and you haven't read it, please go and read your privacy policy and at least have some idea of what's in it. Now you need a procedure to back up your policy, because having a policy is great. It says we're going to do this, but then how do you implement it? That's what the procedure is about. It's having the background step by step so that when you get a question about compliance, when you get a complaint about how personal information is being handled, you actually know what to do with it. And having that procedure, you then need a little bit of staff training. And staff training is about raising awareness with your staff around what exactly is personal information. So there's a whole bunch of stuff that isn't personal information. And there is a whole bunch of stuff that's not necessarily covered by the Privacy Act. So you might have information that somebody says is confidential, which is not personal information, which is therefore not covered by the Privacy Act, which is therefore not covered by your privacy policy, and so you will have a different response to that person than if they did have personal information that you had to disclose. You need to understand what you do with records and document management in your business. Now, I know that this is huge for most people because I know lots of people who can't even organise their folders on their computer or their filing cabinets, and they need someone to help them around that. I've looked at records and document management systems online. I've done Google searches, I've looked at what universities are doing. I had a look at a report where Rio Tinto spent 4 years updating all their documentation management. It doesn't have to be that hard. You can practically deal with it. All you got to do is look at what do I have and how do I deal with it. Destruction of information. What the Privacy Act says is that if you collect personal information for a specific purpose, then you should destroy that information once the purpose is complete. I don't think there are many businesses out there that actually do that. I know for a fact that you join up with a telecommunications provider and they, even though you might stop using them, and 5 years later you come back and they still have your client records. Now, I don't understand how that's not a breach of the Privacy Act. Their argument is, oh, it's for the purpose of providing services. Well, hey, I haven't been your client for 5 years. How the hell can it be part of providing me services? So there's going to be a little bit of, or I anticipate that there's going to be a little bit of argy-bargy around that. Destruction of information, a lot of people are stuck on this. There are different rules and different obligations. A pretty good rule of thumb is 7 years. 7 years, the tax office has pulled it back to about 5 because I don't think they have the resources to chase everybody for back in 7 years. But 7 years is probably a good rule of thumb. There's a huge number of pieces of legislation that deal with the periods of time that you should retain information before destroying it. It's a much more sort of narrow issue and is relevant to your specific circumstances, so we won't go into it in detail, but just be aware that you probably should have something in place, and it'll help you manage your materials as well. Basic compliance, you do need to understand your ICT system. So ICT is information and communication technology. You need to know the basics around what security systems you have in place. So if you outsource it to a service provider and they look after all your IT, you want to know from them what are the security systems in place around that information. How do I know that it can't be just hacked and easily or accessed easily? Now, this is hilarious because it doesn't even have to be a technology system. Vodafone or one of the telephone providers got in trouble because they did an ad on TV, and in the background in the ad was a whiteboard with a whole bunch of phone numbers on it and people's names, and clearly they didn't realize that it was there and on screen throughout the whether it was an interview or whatever it was on TV, but it went all over TV. They had to do some, fairly serious apologising around that and put some systems in place and contact all of the people who were impacted by that. So it is really about understanding your own systems. Okay, we've got another little poll here, if I can find it. And the poll is, could you handle a privacy complaint? Would you know what to do if somebody contacted you and said, hey, I believe you've misused my personal information? Whoa, we got people voting quickly this time. Okay, give that 5 more seconds. 3, 2, 1. Okay, about 30% of you have said yes, you do know how you would manage a privacy complaint, and around 70% have said no, you wouldn't know. Now that's what your privacy procedures are about. It's how do you deal with a complaint that comes in line with your policy. Okay, moving right along. Now we've got, just so you know, I've got about 4 or 5 more slides to go and then questions. So I'm aiming to get this done in the next 15 minutes, including your questions. All right, your risk profiles, what we're talking about here is whether you are seriously facing big fines or not. Now, the fines are starting at around $300,000 for individuals. So if you're a sole trader, that's the kind of potential you're looking at if you're not handling personal information correctly. If you've got a company, then the fines are up to $1.7 million, nothing to sneeze at. Now, a low-risk activity is if you're not actively out there soliciting information, so you don't have a web capture or a name capture on your website, you are receiving emails, maybe not such a big deal, but you're not actually out there actively asking for or collecting personal information. That's a low risk profile. You've got a medium risk profile if you are using a web form to collect a name and email address and building a list. If you've got a reasonably small list, and I'm talking say under 1,000 people, and you're not doing direct marketing. So you might just be sending out a newsletter, and there might be a little bit of marketing in your newsletter, but the newsletter is more an information source than a marketing source. Now, you're high risk if you have a good sized list, you do direct marketing, you are collecting personal information other than from the individual, and this is not collective. These are high risk if you do just one of these things. So collecting personal information other than from the individual is, for example, buying a list, going onto websites and grabbing email addresses, that sort of thing. If you're collecting sensitive information, particularly health information, then you're a higher risk profile. And if you're using overseas call centres or support staff, then you're a higher risk profile. And you need to get this stuff sorted out. So just quickly, I think I have one more poll. Oh, or maybe not. I might have just lost it. Okay. I was going to do a poll here and say, what risk profile do you think you are, whether you're low, medium or high? And I seem to have clicked the wrong button on the management screen and lost the polls, so sorry about that. If you do want to post a quick comment and let me know whether you think you're a high, low or medium risk profile. Okay, we got one high. High-ish, medium, low, excellent. High risk. Okay, fantastic. Thank you so much for putting in these comments. It's really great to get feedback when you're giving a presentation like this. I'm used to having an audience in front of me, and it's really easy to see how people are finding things, and to get your answers like this is great. Okay, so we've got a mixture of low, medium and high risk businesses. For a low risk profile, now I did say when I marketed this webinar that I would give you solutions, and here are your solutions. If you're a low risk profile, we've got a free download plugin. Now the plugin's designed for WordPress websites, but the information is there that you can copy and paste into other web platforms if you're not using WordPress. So if you go into lawfulwebsites.info, you will be able to find that free plugin. We did have an issue today where somebody said it was not working, and we've corrected that issue, so you shouldn't have any problems downloading it. Okay, medium. If you're a medium risk profile, what I've done is put together we've got a website starter pack, and in that starter pack you have both a privacy policy and you have a procedure to back it up. So the procedure gives you the template for how you deal with privacy complaints, how you deal with storing information. Now it's not tailored to your business, but it is as general as I can make it and as applicable to as many businesses as possible. So if you're interested in that, go and have a look. Same website, lawfulwebsites.info, website starter pack will give you the policy and the procedure so that you at least know what you're doing with your information. High risk. If you're in a high-risk category, it's really worthwhile having a chat with me and going through this in a little bit more detail. So what I mean by this is I will send you a checklist or a questionnaire of a number of different things for you to give me information about what you do in your business. Then I'll have a look at the privacy policy you've got and the templates that I use. We'll tailor something that fits with what your business does, and we'll tailor the procedures to fit with what your business does, so that you're then confident moving forward that you've got it sorted before all these big fines come in. So they're the 3 different solutions, and they're based on what you do in your business. Okay, questions. Now I know that there were some questions back in the beginning that I haven't answered, so what we'll do is we'll work through the questions we've got really quickly. As a low risk, this is one of the questions that come in. Where do I stay updated with any changes to privacy and disclaimer law? Okay, disclaimers is risk management and it's more consumer protection than privacy. What you can do with consumer protection is consumer.gov.au is the government website. The information on there is good, it's general, but it'll keep you updated as to some of the things that are happening. With privacy, if you go to privacy.gov.au, again, that's the government website. It tells you what the Privacy Commissioner is up to and what is on their hit list at any given point in time. They do have some pretty good articles from time to time. Their website at the moment is still geared to the existing system as opposed to the new system, so they've got some updating information. I've given it a fairly good look over the last few weeks to make sure that it was accessible. I don't know that the information is terribly helpful for business in complying with the new laws just yet. I'm hoping that down the track that they'll come up with some more practical information. So there's 2 areas where you can have a look, the government websites. If you're an internet marketer, this is another one of the questions that have come up, and you acquire a list from overseas, are you infringing Australian privacy laws? Well, Australian privacy laws are about personal information for individuals. They don't differentiate as to where that individual lives. They differentiate as to where your business is situated. So if your business is in Australia and a complaint is made, even if it's from someone overseas, the fact is your business you're required to comply with the Australian privacy laws. If there's a complaint, you're still liable. So just be aware that just because the information's come from overseas, a complaint could still be made to the Commissioner and you could still be facing issues. It may not be an issue because people may not know the Commissioner exists, but with the accessibility of information on the internet, don't bet on it. Okay, I've got someone with a list of, say, 1,300 people. They send weekly newsletters with special offers, retail online, product-based service, product rather than service-based, and international. Is that a low, medium, or high risk? Well, I would suggest that you're in the higher risk category, particularly if you're relying on the income from that business, because you don't want to be put in a position where you're paying huge fines or you get stopped from a particular activity around your business because you're non-compliant. So that's another thing you've got to look at in terms of your business. Can you afford to lose it? And if you can't afford to lose it, then do what needs to be done to make sure that you are compliant. Now, we had some questions way back at the beginning. What about information that is captured as a screen save on social media, for example Facebook, that could be used as testimonial evidence? Don't be using, if you grab somebody's comments from Facebook and you screenshot them and you use them as a testimonial, then you're not only potentially in breach of privacy laws, you're also potentially in breach of consumer protection laws. Because the consumer protection laws deal with testimonials, and what they say is the testimonial has to come from a real person, it has to be freely given, you need to have their permission, it needs to be current. So it may, if you're going to use what they've said as a testimonial, get them to send it to you separately with a date stamp and their authority to use it rather than screen capture it. Facebook has its own delightful set of rules and procedures. I haven't read them again recently They change all of the time, and you may also potentially be in breach of Facebook rules. So you'd have to go and have a look at that as well. Okay, now let's see, are there any other questions? I'm just trying to see through and see what I've missed. Okay. Sorry if there's anyone with more questions. I'm just scrolling up and down. Don't mean to leave you hanging. What if in your terms and conditions of, say, a competition, okay, the question is, what if they have agreed in the terms and conditions, e.g. of a competition, would that cover providing permission? The whole thing about getting permission is people have to know they're giving it. So you will be familiar with all the websites that say, tick a box if you read the terms and conditions and privacy policy. Travel websites are a great example. You can't actually book your airline flight unless you tick there, yes, I've read your terms and conditions. Now, if you're like most people, you don't ever bother to read them. I read them at least once. If they tell me they've made changes, then I might read them again. But I read them at least once. If you're going to ask somebody, if you're going to, what's happening now with competitions in particular is if somebody's personal information is going to be used for a purpose other than their entry into that competition, it has to be spelt out in order for you to protect yourself or to protect your business. So put it in your business and, put it in your promotion. We'd like your personal information, but make it a tick box option. Either tick box they've got to opt out or tick box they've got to opt in. In Australia you can do either way. If your audience is predominantly US, for example, then you need opt out as opposed to opt in. So you've got, opt in as opposed to opt out. So they've got to agree to go into your list as opposed to having to tick the box to get out of your list, if that makes sense. Okay. Somebody's asked, is our website address law4yourwebsite.com or law4websites.info? Okay, we have, what we're doing is law4websites.info is a legal information pack website. So you can buy a whole heap of legal forms on that website. Law4yourwebsite.com is my business website. It's got a whole lot of information, blogs, articles, bits and pieces, things like that, but it doesn't actually have any products on it anymore. What we've done is separated them both out. So one's sort of a legal forms publication website and the other one's a blog website. So we actually have both of them. They are both ours, but the one that we've been talking about today is law4websites.info. So thanks for that question, Tom. Will I be doing another webinar? I'm happy to do another webinar. If you've got some specific questions or topics that you'd love to hear about, let me know. I regularly give presentations and talks. This is the first time I've done it via webinar. I have been interviewed on a number of webinars before, but as I say, this is the first one we've run ourselves. I've done talks on consumer protection, on contracts, on structures, on all sorts of stuff like that. If you're interested in hearing any of those things, then please do contact me and we can organise something for you. Do these changes apply to incorporated clubs is a question that's come through, and the answer is yes. The Privacy Act changes will now apply to any business, and they refer to entities and organisations. Entities include trusts, partnerships, all those sorts of things, including incorporated clubs. So yes, you will be covered. Okay, somebody's popped up and said they want another webinar. Fabulous. Okay, well, thank you all very much. I really appreciate your time this evening. It's been great having you on board. By all means, feel free to send us an email, contact us, let us know anything else you'd like to hear about, and we will definitely let you all know where the link is to the recording of tonight's webinar. And we've done it in time. How about that? Thanks very much, everybody, and good night.